attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is a continuation in a LawCast series detailing the OTCQB listing requirements. To qualify for the OTCQB, all companies are required to post their initial disclosure on the OTC Markets website and make an initial certification. The initial disclosure includes confirmation that the company is current in its SEC reporting obligations, whether that company is subject to the Exchange Act reporting requirements or Regulation A+ reporting requirements, that all reports that are required to be filed with the SEC have been filed, that all financial statements have been prepared in accordance with U.S. GAAP, and that the auditor opinion is not adverse, disclaimed, or qualified. For international companies, companies subject to the Exchange Act reporting requirement must be current in such reports. A company that is not an SEC reporting company must be current and fully compliant in its obligations under Exchange Act Rule 12G3-2B, if applicable, and shall have posted in English the information required to be made publicly available pursuant to Rule 12G3-2B for the preceding 24 months, or from inception if less than 24 months. That all financial statements have been prepared in accordance with U.S. GAAP, and that the auditor opinion must not be adverse, disclaimed, or qualified in any way. All companies, whether U.S. or international, must have a verification that the company profile is current, complete, and accurate. All companies will be required to file an initial and annual certification on the OTC Markets website signed by the CEO and/or CFO stating the company's reporting status, i.e. whether SEC reporting, Regulation A+ reporting, bank reporting, international reporting, or alternatively reporting, and briefly describing the registration status of the company. If the company is an international company and relying on 12G3-2B, it must be current in such obligations. That the company is current in its reporting obligations to its regulator, and that such information is available either on EDGAR or the OTC Markets website. Disclosing the law firm and/or attorneys that assist the company in preparing its annual report or Form 10-K. Confirming that the company profile on the OTC Markets website is current and complete. Identifying any third-party providers engaged by the company, its officers, directors, or controlling shareholders during the prior fiscal year and up to the date of the certification to provide investor relations services, public relations services, stock promotion services, or related. Confirming the total shares authorized, outstanding, and in the public float as of that date, and listing the names and shareholdings of all officers and directors and shareholders that beneficially own 5% or more of the total outstanding shares, including beneficial ownership of any entity shareholders. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.